for instance, or have you been only to Kiev?
I've been nowhere else in Ukraine, unfortunately. I spent a couple of weeks in Georgia a few years ago, which was really interesting. But no, not in, I really want to go back to Ukraine. Wayne Jordash, who you guys probably know, he's a really, really dear friend of mine for a really long time. And so he was actually the one who invited me. And yeah, so hopefully he'll find a reason to invite me back when people can travel around the world again.
Oh, wonderful.
Колеги, я додала Ірину Марчук також. Будь ласка, розм'ютьте її. Точніше, зробіть її ко-хостом.
Irina, hi, we're making you a co-host so that you can unmute yourself. And I'm very sorry that I have forgot to introduce everyone. Like, Kevin, so this is Maria, my colleague from the Media Initiative for Human Rights, who is the co-moderator and the principal person who reports on war crime trials in Ukraine and also maintains the talk about the ICC and the Rome Statute on Ukraine's agenda. And Maria obviously knows Kevin. And we're very happy to see Irina. And what's the...
She probably has to be added as a host as well.
Yeah,
she is already.
But she's definitely muted, so.
Okay, now it's working.
Perfect.
Yeah,
Working.
Yeah, nice to see everyone.
How are you, Irina?
Yeah, very good. I'm really looking forward to this panel. And I'm so happy that today we won't just be talking about the situation of Ukraine in the ICC, but we have Kevin joining us and we'll be talking about some broader implications of international criminal justice. Because normally
I'm leaving the very Ukraine-specific questions to you, so.
Yeah, yeah, great. Like all the US-specific questions, you know, these are your questions. And it's actually quite exciting because it's for the first time that Kevin and I represent the same institution together.
It's true, although we're in opposite parts of the world. So hopefully in the next few months, we'll be in the same part of the world.
Yeah, exactly.
Okay, colleagues, we have to start in, I think, 1 minute approximately. Колеги, ми можемо зараз додати всіх гостей, які просяться до нас.
Вибач, що перебиваю. Ти просила Ірину зробити сохостом. Це Максим може зробити. Максим, зроби, будь ласка.
Так. Гаразд. Але я думаю, що Максим, вдалося?
Ми в ефірі. Все у нас нормально.
Гаразд. Зроби, будь ласка, Ірину ко-хостом, і ми починаємо.
Так.
І давайте запускати всіх. Okay, colleagues, we have to start now. Good morning, good afternoon, and good evening, everyone. Welcome to the webinar dedicated to International Criminal Court, its internal dynamics, geopolitical context, and Ukrainian case precisely. It's the second event from our series of webinars called International Law Talks, which is presented by Katerina Busol and myself, Maria Tomak. And this series is co-organized by the Media Initiative for Human Rights, Ukrainian Helsinki Human Rights Union, with the support of the USAID Human Rights in Action program. And today, I would like to start just with the fact that today Ukraine marks the 7th anniversary of the occupation of Crimea, and probably it's a good occasion and a proper day to discuss the perspectives of Ukrainian case. However, when we were thinking about this webinar, we were really hoping that we can bring some broader perspective for the Ukrainian public, because we're very much focused at Ukrainian case and what is going on with the Ukrainian case and whether Ukraine should ratify the Rome Statute, which is still on our plate, so to say, this issue in the internal discussions. But we can't see what is going on in the ICC. We can't see what is going on around the ICC in terms of geopolitics, its relations with the US, for instance, with other countries, with African countries. And I would say that it's a complex issue. So we're going to look at this issue today with the prominent guests, I should say. And before I will give the floor to Katerina and she will present our guests, I would like to say a few technical things which might be useful for you. So we are going to speak today in English, but you can choose the Ukrainian translation by pressing the glow button in the bottom of your screen and choose the option with German language, which is basically Ukrainian one, a bit confusing, but still. Отже, для україномовної аудиторії я хотіла б зазначити, що ви можете слухати україномовний переклад сьогоднішнього заходу, тому що сам захід буде англомовний, і вибрати опцію German, натиснувши на кулю внизу екрану і вибравши відповідну опцію. We are also live streaming to the Facebook with the Ukrainian translation and to the YouTube page of Ukrainian Helsinki Human Rights Union in the regional English language. And also you can ask your questions in the chat here in the Zoom, and we will pick up probably, and we will take the most interesting questions and we'll address them, address our guests with them. So without further delay, I give the floor to Katerina.
Dear friends, dear colleagues, thank you for joining us again and dedicating your lunchtime, in Ukraine at least, to international law. I'm very grateful to our two amazing speakers today who are joining us from different time zone, and especially for Professor Heller. It's late at night, but I think it also proves the commitment to the international law and the broader ICC issues which we would want to discuss today. So today we're joined by Professor Irina Marchuk, who is the Professor of Law at the University of Copenhagen. And Irina has been very instrumental in bringing together the Ukrainian civil society, her expertise in international criminal law and international law broader, and helping the Ukrainian investigators and prosecutors in their attempts to bring the perpetrators of the gravest crimes in Ukraine to account. And also we're joining, and we're very grateful to Professor Kevin John Heller, who's joining us from Australia. He's a professor of international law and security at the University of Copenhagen and a professor of law at the Australian National University. Professor Heller has written a lot on such a wide number of issues of international criminal law. Most recently, he has submitted a joint opinion, an amicus curiae, with the Guernica 37 International Justice Chambers on the issue of Palestine. And I'm sure that many people here in the audience read and follow both professors a lot. So without further delay, I would like to start our conversation with quite a topical question. Very recently, the ICC, the International Criminal Court, has got its new prosecutor. Professor Heller, how would you assess what would be the biggest challenges the new prosecutor should address? And most importantly, how do you think this new person might change his attitude to a potential investigation in Ukraine, in the Russia-Ukraine armed conflict?
Well, first, let me start by thanking both of the co-moderators for inviting me. It's a real honor and pleasure to appear today. I wish it was not via the internet, but the times being what they are, we don't really have much choice. Let me start by saying that I think the state parties got the choice right. I think Karim Khan is a brilliant choice for the next prosecutor. He has an incredible array of experience as a prosecutor, as a defense attorney, as an investigator for UNITAD in Iraq. He's a truly amazing lawyer. And I think if anyone can help turn around the ICC, it will be he. That said, you can't really envy the situation that the new prosecutor is going to find himself in. The court has always suffered from a lack of funding. Its funding increases very small amounts, if at all, each year. But at the same time, the workload of the ICC increases exponentially. Just think about the past couple of years. We now have the Myanmar investigation. We have the Afghanistan investigation. We have soon the Palestine investigation. We have the prosecutor Fatou Bensouda saying that she intends to open the Ukraine investigation. She says she's going to open the Nigeria investigation. Guinea is close to a decision. Venezuela is close to a decision. The Philippines is close to a decision. An explosion of situations under investigation and not more resources to actually accomplish it. So the first thing that Karim Khan is going to have to do is make some extremely difficult decisions about which investigations to prioritize. Where Ukraine falls in that is a really open question. Fatou Bensouda has always been very kind of hedging about how quickly the office was going to begin to affirmatively investigate in Ukraine. And she's basically said with both Ukraine and Nigeria that they're not going to be at the top of the list because of the Afghanistan investigation and Myanmar and Palestine. Whether Karim will change that order of priority, I don't know. As I'm sure we'll have plenty of chance to talk about, there are some real difficulties in the Ukraine situation, namely one of the sides, and the sides that is primarily responsible for international crimes, is extraordinarily difficult, if not possible, to investigate, that of course being Russia. And Fatou Bensouda has highlighted the difficulty of trying to investigate Russian criminal responsibility, given the fact that there is no access to the Crimea, that there's fighting going on in eastern Ukraine, etc. So I think initially you will see continuity. I don't think that with regard to Ukraine, Mr. Khan will fundamentally change the OTP's approach. How that plays out over the next couple of years, I think is a much more difficult thing to prognosticate.
Yeah, thank you. Can I add something? So I'm just wondering if I could follow up with your comment.
Sure, would be great, Irina, if you can answer also the question of Katarina.
Yeah, thank you. So I also agree with Kevin. I think that state parties got it right. It was a very close race between Karim Khan and Fergal Gaynor. Karim is very tough-minded. And I think the question that has been posed and has been circulated in media and various blogs, is Karim courageous enough, brave enough, and tough enough to take on powerful states? But I think that Karim has no choice. He cannot back from investigating the situation of Afghanistan, which is currently at the investigation stage. Now we'll also have the situation of Palestine that is moving towards the investigation stage. I think maybe the life of Karim was made a bit easier as one quite highly sensitive situation, and that the situation of Iraq, UK is no longer on the watch list of the Office of the Prosecutor. If you remember and you were closely following the developments in the ICC, in December 2020, Fatou Bensouda concluded that she will not be proceeding with the investigation of allegations of war crimes committed by UK forces in Iraq. As we know, Karim is a UK national, so maybe it's a great sense of relief for him that he will not have to deal with this kind of investigations. But I think, answering the question, I think that Karim is tough-minded, and in his own words, he has thick skin and resilience to take on powerful states. So I don't think that Karim would shy away from taking on potential cases implicating nationals of powerful states. I also agree with Kevin that I don't think that Ukrainian situation is on the top of the priority list. And we'll be maybe talking a bit more about the ratification of the Rome Statute. First of all, Ukraine is an outsider. Ukraine accepted the ad hoc jurisdiction of the ICC on 2 separate occasions, but Ukraine cannot really demand that the new prosecutor will prioritize the situation of Ukraine, considering that Ukraine does not want to move ahead with the ratification process. Also, we heard from Kevin that number of other preliminary examinations have been completed. For example, the situation of Nigeria and other situations are about to be completed. So why would the new ICC prosecutor prioritize the situations of non-ratifying states if there is a lineup of situations that the new prosecutor has to deal with? And also, the prosecutor would really have to look into the 2 most controversial cases, and that's the situation of Afghanistan, potentially implicating American nationals, and also the situation of Palestine, potentially implicated Israeli nationals. But if we are to think, was it the right choice? I think it's right. It's actually quite satisfying to see that we have someone with great potential and someone who is a veteran of international criminal justice, a familiar face in international law circle, qualified, has high moral values, who was elected to the position of the ICC prosecutor.
Just to follow up a bit on the capacity of the ICC, which you've touched upon just. So for instance, Kevin was talking about the financial side of the story, and I was amazed by the fact that even in the statement concerning the Ukrainian case, the previous prosecutor emphasized, I would say very explicitly, that there is a lack of resources within the ICC. But also when it comes to this political capacity of the court to bring to responsibility of someone like Vladimir Putin, because actually these doubts regarding whether the court has the capacity was, I think, in the core of this whole story, with the attempt of some of the African countries, or intention of some of the African countries to withdraw from the ICC. And we know that in 2017, Burundi has actually withdrawn from the ICC. So my question is, Ukraine, hopes very much that ICC will help us to bring to responsibility those people who are interlinked with the Russian aggression against Ukraine, as it's defined. So is it possible at all? How do you think? Because it's not, of course, only depends on the prosecutor, but also on some other factors. So given all those factors, do you think the ICC has the capacity in this historical moment to bring to responsibility such a powerful guys? The question to both speakers, of course.
Rina, do you want to take that one first?
Yes. So I think the question is a tough one, but we have seen successful and less successful prosecutions of the former heads of state. For example, if we look at the cases that have been initiated in the ICC, the very first case against the sitting head of state, now former head of state, was the case Omar al-Bashir. And that, of course, stirred a backlash against the court, and that led to the African bias drama that followed afterwards. But also we saw the cases initiated against the former president of Kenya, Kenyatta, and also the case against the former president of Ivory Coast. So it's not unusual that we'll have persons who have the most senior jobs who are being prosecuted on the charges of international crimes. The question that Maria was asking is a tough question. So can we expect that Vladimir Putin, who is the commander-in-chief in accordance with the Russian constitution, will be the one who will be on the priority list of the new prosecutor? I think it's naive to believe that Vladimir Putin will be the first one on the list of suspects. Why? Because that will just politicize the work of the court and would detract completely from the gravity of the Ukrainian situation. And we will shift our discussion to the immunities, that the ICC is a legitimate body, cannot initiate cases involving heads of states who are sitting heads of states and who are entitled to immunities under customary international law. So I think that the new prosecutor would not really look at the responsibility of Russian nationals at the highest level, including the president of Russia. That, however, does not mean that the ICC prosecutor will not be willing to open cases involving Russian nationals who are closer to the occupation of Crimea in terms of military chain of command or political leadership, and who are also closer to what's happening on the territory of Donbass. So, to answer this question, I think it's not only Ukraine, but also Georgia hopes for that Russian nationals will be the one bearing responsibility for the crimes that have been committed in South Ossetia. And when we talk about Ukraine, these are the crimes that have been committed in Crimea and Eastern Europe. However, we also have to keep in mind that by virtue of his mandate, the prosecutor has to prosecute and investigate crimes that have been committed by all sides to the conflict. And so here we have Russian nationals, we have senior members of the occupying authorities in Crimea, we have Ukrainian armed forces, and we have pro-Russian separatist forces. So there are 4 different sides of the conflict that we are talking about, and it will be up to the prosecutor to decide against whom the prosecutor will initiate individual cases. If we were to look at the 2018 report, which was published by the outgoing prosecutor Fatu Bensouda, she mentioned that the overwhelming majority of crimes were committed by the pro-Russian rebel forces in Eastern Ukraine. So we might expect that the first individual cases that will be opened, provided, of course, that the pretrial chamber approves investigation, will be against the members of the pro-Russian rebel forces. So this is my best take on that. But I don't think that Vladimir Putin will be the first one on the list.
Thank you, Irina. Kevin, what's your take on that? So you've just mentioned that it's almost impossible to investigate Russian crimes in Crimea, for instance. So is it possible to bring to responsibility Vladimir Putin and his allies?
I mean, I largely agree with what Irina says, and insofar as we differ, it's just that I'm perhaps even a tad more pessimistic than she is. There's no question that the ICC has jurisdiction over the nationals of non-state parties, regardless of what the US and Israel like to claim. But actually prosecuting individuals who are nationals of non-state parties is a very different issue. Obviously, Russia has no obligation to cooperate with the court. It can stonewall all it wants, and there's nothing in international law that says that it can't. Same with the United States in Afghanistan, same with Israel in Palestine. The ICC has a problem getting cooperation from states that are members of the court, not arresting Omar al-Bashir. I think there was like 19 different states that he actually paid visits to that didn't arrest him. So if they have a hard time getting cooperation with member states, think how hard it is with non-member states. And I think that this really points to something that's very ironic. And I think that particularly Ukrainians really need to be aware of, that when a state refers a situation in which its own nationals are involved, not referring a state somewhere on the other side of the world, but a conflict involving its own nationals, when that self-referral involves a non-state party like Russia, there is going to be a distinct possibility that the first individuals prosecuted will be from Ukraine. Because Ukraine, having filed the declaration accepting the jurisdiction of the court, will presumably cooperate more with the court than Russia will. That will make it easier to investigate Ukrainians. Now, as Irina said, there is no question that the OTP believes that the majority of the crimes and the most serious crimes are not on the Ukrainian side, but it is those lesser crimes, less serious crimes, it may be the ones that the OTP can investigate more effectively when in fact the OTP begins to investigate crimes in the Ukrainian situation. So that's just something that Ukrainians need to be aware of, and it's something that Palestinians need to be aware of, that it's much easier to investigate Hamas shooting rockets at Israeli civilians than it is investigating Israeli crimes in Gaza and in the West Bank. And again, it doesn't mean that those crimes are more serious. I would argue that they're less serious, but when you're a prosecutor, you have to decide, what can I actually prove? What suspects can I get in the dock? What evidence can I actually obtain? And that is a huge problem when you're talking about nationals of a non-member state.
Okay, thank you. It seems like we're being here a kind of devil's advocates, because we're persuading all the time Ukrainian public that we need to ratify Rome Statute in order to bring to responsibility the Russian Federation. But the first in the row will be Ukrainians, maybe. Yes, Katerina will ask you the next question, but before that, I would like to ask you to speak as slowly as it's possible, because our interpreter have some complicated tasks to interpret everything accurately. And also, I would like to invite all the participants to ask your questions in the chat. We will take them in 20 minutes, probably. Katerina, would you like to proceed?
Thank you, Maria. I actually have a question to Irina. Irina, I remember speaking to you probably like 2 years ago. You were drafting a section, I think, on preliminary examination for some publication, and you commented actually on the efforts of domestic authorities. And you said that you had one draft before you met the local Ukrainian investigators and prosecutors, but then you corrected your draft because you consulted them and you saw, like, in practice all the hurdles that they were facing. I was just wondering, what progress have you seen in Ukraine's domestic capacities to deal with the Crimea and Donbas crimes? And what do you think Ukraine could have done better but hasn't as of now? Thank you.
Yeah, thank you, Katerina. Yeah, and you are right. I was writing an academic article sitting in my ivory tower in Copenhagen. And I included a sentence saying that Ukrainian national authorities were not up to the task to prosecute international crimes. And then I was invited to give a few trainings to the military prosecutors and also prosecutors who were working for the Crimean prosecutor's office in exile. And I realized that, I could not make such a sweeping statement that Ukrainian national authorities were not interested in applying international humanitarian law, didn't do anything in terms of national capacity building. And I decided to rewrite this section completely, actually commending Ukrainian national authorities for undertaking the first steps in the effective prosecution of international crimes. I would like to say that I have seen a huge leap in knowledge in international humanitarian law and international criminal law among Ukrainian legal professionals. After 2016, virtually not a single prosecution office in Ukraine qualified conflict-related crimes under the umbrella of international humanitarian law. What was a game changer was the annual report on preliminary examination activities, which was published in 2016, where the outgoing prosecutor Fatou Bensouda found that the rules of international humanitarian law applied to the occupied Crimea and applied to Donbas. The first national authority who picked up on the report was the Crimean prosecutor's office in exile, and they decided to requalify the crimes under the umbrella of international humanitarian law. So this progress did not only take place within the Ukrainian national authorities. The NGOs have done an amazing work documenting international crimes. And maybe in the beginning, the legal qualification of these acts was not very accurate, and there were just some facts that were communicated to the International Criminal Court. We could see that there was immense capacity building within Ukrainian NGOs, who actually now, when they submit their communications, not only they're able to present the facts, but they're also able to package this facts within the framework of international humanitarian law, international criminal law, and also account for the criteria that have to be met in order for the ICC prosecutor to move ahead with the preliminary examination. We know now that the situation of Ukraine is a bit in a state of limbo. Also, what was an achievement, and this is the last point, is that in 2018, there was a specialized unit which was created within the General Prosecutor's Office with a very long name. It's the Department Overseeing Criminal Proceedings in relation to the crimes arising out of the armed conflict. And this is an equivalent to war crimes units that we have integrated within police and prosecution in European countries. So this, of course, should strengthen the capacity of Ukrainian national authorities to deal with international crimes. And I read the latest interview, which was given by Gündüz Mamedov, who is the deputy chief prosecutor of Ukraine. He gave very encouraging statistics, saying that over 200 criminal proceedings were initiated in relation to conflict-related crimes. But the major downside that has been experienced by Ukrainian national authorities, that the notices of suspicion in relation to conflict-related crimes do not really translate into meaningful indictments, which are taken further to Ukrainian national courts. And maybe this is something that we could discuss further.
Irina, let me follow up on this matter. So we have this evolution of Ukrainian law enforcement in terms of their professionalization in investigating international crimes. But do you still think that this idea of hybrid courts is actual? I mean, that idea of engaging some of the international judges potentially or investigators in order to deal with these cases in the occupied territories?
Well, I'm sure that Kevin can also reply to these questions. There were successful examples of hybrid tribunal of international character that were established. For example, the Special Court for Sierra Leone and the Cambodia Tribunal. These tribunals were established to enhance national capacity building. They were established upon the request coming from the national government to the United Nations. The composition of these tribunals or courts was normally mixed. So you would have national and international judges working alongside each other. The benefit of having these tribunals is that you will be able to prosecute a larger number of people. So even if in the most optimistic scenario, the ICC will initiate cases within the situation of Ukraine, we are talking about a handful of individuals who might face justice in the ICC. And so we have either few individuals who are tried by the ICC, or we have national courts that maybe are not entirely ready to deal with conflict-related crimes. So I do believe that the establishment of the hybrid tribunal is an attractive option for Ukraine, but there are many challenges that come with that as well. Who will provide funding? Is there a political will for establishing such hybrid tribunal? We know that when anti-corruption court was being established, there was a great resistance to have international judges that will be incorporated within the panels of national judges. So, you know, there is not an easy solution, but clearly the hybrid tribunal of international character will be able to close the impunity gap for international crimes.
Thank you. And Kevin, going back to this broader geopolitical context, one more interesting question, and probably it's very important for the operation of the ICC, is its interaction or relations with the US. So I would say that it has been quite controversial, probably. So we have, of course, the sadly famous sanctions imposed by the Trump administration against the prosecutor and judges, I think also, but also we have the cooperation, the history of cooperation between the US and the ICC, and probably one of the most recent indictments of Dominique Ongwen happened with the help of the US. Actually, they brought Mr. Ongwen to the ICC, to The Hague. So now with the Biden administration, and actually I think that Department of State has already made a statement that they're willing to, I quote, thoroughly review the US sanctions against the ICC, but still they are, I quote, disagree with the ICC's actions relating to the Afghanistan and Israeli-Palestine situations. So what it means and what is going to happen next? What's your prediction?
Oh, simple, straightforward, easily answered question. To begin with the sanctions, I mean, clearly the US has always been ambivalent about the ICC, and truly one of the only kind of truly bipartisan positions in American politics is never to join the ICC. It doesn't matter whether it's a Republican or a Democrat, the US is never going to join the court. That doesn't mean that they're always as hostile to it as the Trump administration was. And without boring you with an hour discursus on the history of the US ICC relations, you basically see incredible opposition initially through the Bush administration, and then kind of a gradual kind of softening of opposition and a willingness to work with the court when the US's interests dovetailed with the ICC, such as in Sudan with Bashir and the Darfuri genocide. So over time, you had warmer and warmer relations and a willingness of the US to work with the ICC when it was in its interest to do so. That obviously changed under Trump. They went back to the kind of John Bolton, let's try to destroy the court as quickly as possible approach. And I have to say, I think that it was really an own goal by the United States. I don't think the sanctions accomplished anything other than to make the US look really bad, to further opposition among European allies against the United States. Didn't really affect the operations of the ICC at all. I think they took away one of Bensouda's credit cards and they wouldn't let her into the country for a couple of meetings. But really the ICC just went on about its business. And all Trump really did was make sure that there was even more support from the court than there would have been without the sanctions. So it wouldn't surprise me if the much more enlightened Biden administration got rid of the sanctions. I think you'll probably see Biden going back to kind of the Obama era approach, which again was what they called constructive engagement. When it was in the US interest to support the court, like an Ongwen or an Ntaganda, they did so. When it was in the US interest to oppose the court, like Afghanistan or Palestine, they would oppose the court. I think that's what we will see. Now, the last thing to say, and I think this is really interesting, the US takes the position, as you kind of hinted at, that the ICC doesn't have jurisdiction over nationals of non-member states. And when they talk about that, they always talk about it in the context of the US in Afghanistan and Israel in Palestine. Well, it also applies to Russia in Ukraine and Russia in Georgia. If they are true to their own legal principles, they would be just as opposed to the Ukraine investigation as to the Afghanistan and Palestine ones. Now, I don't think they will ever take that position publicly because obviously they have a kind of a realpolitik interest in limiting Russian power as much as possible. But it's worth flagging that the legal issue is exactly the same. And if they were truly consistent in their principles, they would be just as unenthusiastic about Ukraine and Georgia as Afghanistan and Palestine. So I guess it will be interesting to see what the rhetoric of the Biden administration is going forward in that regard.
Kevin, thank you. And I would like to follow up on that actually on Palestine and Ukraine. There have been actually quite a few parallels drawing in the commentaries that they're both like smaller states trying to pursue justice, from the bigger states like Israel and Russia. And they obviously cannot have all their concerns adjudicated by one court, therefore they go to different courts. So basically, a statehood issues aside, there are some parallels between Ukraine and Palestine. So my question would be, how do you assess their lawfare strategies? Are they similar in a bit, and how do you see their efficiency generally, and with respect to the ICC in particular?
It's a very good question and an interesting comparison. I think Palestine has been extremely smart about their lawfare strategy. They convinced the UN to upgrade their status to non-member observer state. That allowed them to ratify the Geneva Conventions and join UN agencies and ratify the Rome Statute. And they've basically parlayed that into an ability to get the ICC to investigate. And we're not going to get into all the legal details of that, but clearly they have succeeded in getting the ICC to take an interest in crimes committed by Israel and also by Palestinians. Beyond that, though, I don't think the comparison to Ukraine is very good. And the reason it's not very good is Ukraine is in a much better position than Palestine. Palestine does have its supporters around the world, but even its traditional supporters, the Arab states, they have interests in not upsetting Israel too much, in containing Iran, in placating Saudi Arabia. The Palestinians are kind of without major supporters in the world, and that's going to make it very difficult for the OTP to investigate successfully in Palestine. Ukraine is not Palestine. Ukraine is incredibly geopolitically important to Western Europe, very important to the United States, in terms of containment of Russia. So I think there will always be far more goodwill and far more support from powerful Western countries and powerful ICC member states and powerful members of the P5 trying to protect Ukraine and advance Ukraine's interests in a way that Palestine will never have. Obviously there are limits. When your opponent is Russia, you have a P5 state, and so the Security Council is kind of off the board. But in terms of all of the other potential judicial remedies and political remedies, you'd be much better off being a Ukrainian than a Palestinian these days.
Yes, I agree with Kevin that Ukraine is not Palestine, but of course it's interesting to see how states with weak geopolitical presence, like Ukraine and Palestine, they use all available tools under international law to initiate lawsuits in international courts. For example, when you look at Palestine, Palestinian authorities lobbied to get the non-member observer status at the UN, which allowed them to exceed international treaties. And based on that, in 2015, finally, Palestine was able to ratify their own statute. But in addition to that, Palestine went one step further and filed the case against US in the ICJ based on the breaches of the Vienna Convention on diplomatic relations, following a very unfortunate decision of the Trump administration to move its embassy to Jerusalem. As we know, the status of Jerusalem is contested. When it comes to Ukraine, Ukraine has been a front runner in a number of disputes that have been initiated by one state against another state arising out of a single armed conflict. I think to some extent, Ukraine replicated the strategy of Georgia. We know that following the 2008 war, Georgia filed the case against Russia at the ICJ on the basis of the alleged violations of the Convention on the Elimination of All Forms of Racial Discrimination. Also, Georgia filed a number of interstate applications at the European Court of Human Rights. And then the ICC prosecutor decided to initiate a pro motu investigation in relation to the crimes arising out of the armed conflict. But Ukraine managed to beat Georgia by a mile. Not only Ukraine accepted the ad hoc jurisdiction of the ICC in relation to the Maidan crimes, Crimea and Donbass, also Ukraine initiated a lawsuit at the ICJ against Russia involving the violations of the Convention on the Elimination of All Forms of Racial Discrimination and also the Terrorism Financing Convention. Ukraine lodged 8 interstate disputes against Russia to the European Court of Human Rights. That number, thanks God, was downsized by judges to 5 interstate applications, but still, this is the largest number of interstate applications which has been brought by one state against another. In addition to that, Ukraine also decided to pursue arbitration proceedings under the United Nations Convention on the Law of the Sea. So the proceedings in relation to Ukraine's coastal rights in the Black Sea, Sea of Azov, and separate proceedings in relation to the unlawful detention of Ukrainian crew members during the 2018 Kerch Strait incident. So, of course, Ukraine as a state has had multiple options that were not available to Palestine to pursue justice in different international courts. The question that the Ukrainian government should be asking yourself, is this strategy coherent? And I think that when we look at the different disputes that Ukraine initiated in international courts, sometimes it's very difficult to see what was the purpose behind bringing proceedings concerning, for example, the same incidents before different international courts. For example, we have interstate application concerning unlawful detention of Ukrainian crew members pending determination by the European Court of Human Rights. And then we have a similar case pending determination by the arbitration tribunal, which is constituted under the United Nations Convention on the Law of the Sea. Also, Ukraine has been advancing some mismatched arguments in various international courts. For example, in the ICJ, Ukraine was arguing that the policy of the occupying authorities is the culture of erasure against those who are deemed to be hostile or disloyal towards the occupying authority. In the European Court of Human Rights, Ukraine was arguing that the very same acts constitute an acts of persecution, and this is persecutory policy. Also, for the purposes of proceedings in the ICJ, Ukraine is arguing that acts that clearly fall under war crimes also constitute underlying terrorism offenses. So I think that now the majority of cases have moved through the preliminary objection stage, or they're like halfway through the proceedings. And now these cases have moved on to the merits. And it's actually right now that Ukraine has to make sure that it's advancing a coherent litigation strategy across different international courts, and its arguments do not contradict each other.
Thanks a lot, Kevin and Irina. And I have a follow-up question as regards the strategy, or rather the vision that Ukraine has in its approach, not just to international courts, but also to the justice domestically. Ukraine has had a sort of prosecutorial perception of the ICC and just the desire to convict. But as we know, victims and their perspective has a very strong component in the court. So Kevin, could you please comment on the correlation between these two components, the prosecutorial and the victim's perspectives? And then perhaps, Irina, you could address the question whether Ukraine is also missing this victim's perspective domestically, not only in its adjudication, but in its broader transitional justice process. Thank you.
So I think it's a really important question, because it's very tempting and not completely inaccurate to just say, well, of course the OTP and victims have the same interests. They both want to convict the perpetrators of international crimes. But that really kind of conceals as much as it explains, because when you get down to kind of the more micro level of prosecutorial policy, then all of a sudden you start to see differences emerge between the OTP and victims. Let me give 3 examples of that. The first would be in terms of, what crimes are even within the jurisdiction of the court. I would imagine that many Ukrainians would like to see Russians prosecuted for the crime of aggression. Clearly, as that crime is understood substantively, Russia is responsible for aggression against Ukraine, but there is no jurisdiction at the ICC for aggression. It's in the statute, but I won't get into all the details, but Russia as a non-member of the ICC, there's no possibility of the crime of aggression ever being brought against Russia. In terms of—
Kevin, I'm very sorry, may I just add that, as I know you were one of the people who contributed to the negotiation of the, of the newly added article on aggression to the Rome Statute. Just for the audience, for those who don't know, that you participated in the negotiation on it.
much more the definitional side, though, and I think I've been quite stridently critical of the jurisdictional regime that was adopted for aggression, because it's not the same as the normal jurisdictional regime for war crimes, crimes against humanity, and genocide, and it eliminates, as a matter of law, all non-member states like Russia. I think that's a problem. But it goes even beyond that, you know, again, the victims in the OTP want convictions, but in any situation, Ukraine or any situation involving significant violence, there are far more victims than there are cases to prosecute, or far more victims than the OTP has the ability to prosecute. The OTP has to make very difficult decisions about which crimes to investigate, which perpetrators to bring charges against, and invariably, there will be victims whose particular suffering is not recognized by the court in a case, and they will feel quite understandably aggrieved by having their suffering left out. But the OTP can't prosecute everything. And then even beyond that, even within the victims whose suffering is recognized by the court in terms of an actual prosecution, it's not necessarily the case that the OTP will pursue exactly the same legal strategy that the victims would want. If you look at the first prosecution at the ICC, Thomas Lubanga, the Congolese warlord, the victims were irate with the Office of the Prosecutor that Luis Marinho Ocampo only charged Lubanga with the recruitment of child soldiers. They wanted him to prosecute sexual violence, of which there was a massive amount. They wanted him to prosecute crimes against humanity of a whole variety of types of suffering. He made a decision, and maybe justifiable, maybe not, to go after the crime that he could prove the easiest and the most quickly. So even when a victim is recognized in a court case, it doesn't mean that the OTP is going to take exactly the same approach to the case that they would. And invariably, that means that there will be victims who feel left out and alienated by the process. And the ICC, unfortunately, has not proven very skillful at managing the expectations of victims. When they open a formal investigation, as they no doubt will in Ukraine, that is going to raise expectations that the ICC will do something about the suffering of ordinary Ukrainians. And I hope they will. But even if they do, it's not going to be the kind of, as Irina said, massive, let's prosecute everybody approach. The ICC simply is not capable of doing that. So victims always have to approach the court's work with a sense of realism and not get their expectations too high, because they will almost certainly be dashed at some point.
Thank you very much. Irina, what's your take on this point, and especially in the Ukrainian domestic context?
Yeah, so first of all, I agree with what Kevin said, and I would like to say that it was actually a conscious decision of the drafters of the Rome Statute to make sure that victims actively participate in the proceedings. Victim participation is one of the most important innovations of the Rome Statute. And although the victim participation framework is provided for by the Rome Statute, I don't think that the drafters envisioned how exactly this victim participation framework will work in practice. And I think that Kevin gave very good examples from the Lubanga case, but I think that at the reparation stage, we could see that clearly the expectation of victims were not aligned in generally with the general ICC policy. So for example, former child soldiers, they expected to get some financial remuneration for the crimes that they had suffered. Just to give a perspective, those who were enlisted and conscripted as child soldiers, these are the children who lost their childhood. They did not get any education. They had their lives shattered. And the least they expected from the ICC was to obtain some sort of financial remuneration for their suffering that they could use in order to rebuild their shattered lives. What the judges decided that the victims will be getting some form of symbolic reparations. And there was a lot of discussion that followed afterwards that the ICC is not to the task to satisfy the demands of victims. And so, although Ukrainians should understand that when the first cases are being brought before the ICC, there will be opportunities for victims of the crimes to participate in the proceedings. I don't think that victims should have very high expectations that they would be receiving some form of just satisfaction or financial remuneration as part of the ICC reparations program. for one simple reason, that the ICC does not have unlimited resources. The trust fund for victims is underfunded. And so here, I think it comes back to the previous question when we talked about multiple venues that not only the state of Ukraine pursued in relation to address the violations of international law by Russia, but also, for example, many victims, I believe over 8,000, filed individual complaints to the European Court of Human Rights. And so I believe that these victims expect that there might be there will be some just satisfaction decisions at the end of the proceedings. However, we know that Russia has a history of non-compliance with the decisions of the European Court of Human Rights. So, victims should also lower their expectation, not thinking that by the end of the proceedings, Russian state will be the one footing the bill. And it's been a political discussion. So if Russia is the one who caused all this chaos and mess on the territory of Ukraine, clearly they are supposed to pay for everything. For the seized property, the property that was destroyed, also covering the cost of victims who have been forcibly displaced. I believe now we are talking about 1.5 million Ukrainians who were displaced in total from the occupied Crimea and Eastern Ukraine. And I would like to ask our government, what are the obligations of Ukraine in relation to these individuals? I don't think that the government of Ukraine has also questioned itself serious on the commitment to help the victims of international crimes. I feel that all the blame has been shouldered on Russia, but the Ukrainian politicians have not been able to agree on maybe some subsidies or some steps that could be undertaken to alleviate the suffering of victims. So I think that the subject of reparations is something that clearly falls under the transitional justice scenario, and we should not only be expecting that here will be the ICC with a generous reparations programs, or Russians will have to make very generous payouts if they lose in the litigation before the European Court of Human Rights. But the Ukrainian government should also question itself on how it's going to help the victims of international crimes. And I think that the Ukrainian government can do better than what it has done until now.
Irina, you've been referring to the other cases, Ukrainian cases in the international courts like ECHR and the ICJ. Maybe this question might sound a bit naive, but still, do you see any interlinks between these cases potentially, whether, for instance, the recent move of the ECHR may influence somehow Ukrainian case in the ICC and vice versa, potentially, whether there can be any kind of effects from one court's moves at the other?
Yeah, clearly, I believe that there has been an emergence of parallel proceedings, and not only in relation to the situation of Ukraine. Let's look, for example, at the situation of Myanmar. So we have the situation which is currently considered by the ICC, but we also have a separate case which was brought by the Gambia before the ICJ. So the question is, will international courts accept each other's fact-finding? What about the questions of law? Will courts agree? How this interaction between the courts can strengthen the landscape of international law more generally? And I think the major problem of the situation in Ukraine is fact-finding. We have seen a lot of disinformation and misinformation shared about the conflict. So, for example, if you were following the proceedings before the ICJ, in which Russia participated, I had a feeling that I was hearing about two completely different conflicts. The parties could not agree on that. And it's one thing when Ukraine is voicing its grievances before different international bodies at the United Nations Security Council, arguing that Russia has consistently violated its obligations under international law. But it's completely another situation when we have international court with a strong reputation who will do who will actually conduct some credible fact-finding. And I think it's important for Ukraine to get the facts straight. And as we know, also Ukraine has been pursuing a sanctions policy against Russia. We have also seen that European states start to forget about the occupation of Crimea. We know that, for example, Russia was expelled from the Parliamentary Assembly of the Council of Europe after the occupation of Crimea in 2014, but was able to return comfortably to the table of negotiations last year. And so instead of Ukraine keep rubbing it in the face of international community that Russia is violating international law and everyone gets tired of it, I think it's important that we have some authoritative decisions coming from international courts that will first of all conduct credible fact-finding, and then most hopefully for Ukraine, they will establish violations of international law by Russia. This could be used as an effective tool to continue with the sanctions policy against Russia, and I think that this is something that will help Ukraine more generally at the international arena.
Thank you for raising this extremely important issue of disinformation and misinformation. Kevin, do you think Ukrainian conflict is somehow unique in these terms, and whether it may somehow influence the legal dimension of the conflict of the issue in the international courts? I mean, all these special information operations, as it's called now by the Russian Federation. So is it an important factor when it comes to the legal implications?
In theory, sure. Is it fundamentally different than any other conflict? I mean, maybe, kind of quantitatively, qualitatively, probably not. I mean, as Irina highlighted, fact-finding is the most difficult thing that particularly an international criminal court can do. And I don't have too much to add other than just to remind people that the ICC is a court of criminal law. It's about individual criminal responsibility, not about state responsibility. And when there is someone in the dock at the ICC accused of an international crime, it is going to be the prosecutor's burden to prove all of the facts beyond a reasonable doubt. And he or she is not going to be able to just say, okay, well, the ICJ said so-and-so, or the European Court of Human Rights said so-and-so. All of those facts are going to have to be proven again. And that is not going to be an easy task, no matter who is being prosecuted, no matter what side of the conflict is being prosecuted.
Thank you, Kevin. And actually, I'm taking the first question from the audience, and I would like to ask it to you. It's about the ratification of the Rome Statute, because it's still a big topic in Ukraine, whether having issued the declarations recognizing the jurisdiction of the court, Ukraine also needs to ratify the Rome Statute. So the question is twofold. Could you explain whether the ratification of the Rome Statute will in any way impact the jurisdiction of the court that Ukraine has already recognized? And the second bit of the question is that if Ukraine decides to withdraw its two declarations, and unfortunately there are such discussions domestically. So if the country decides to withdraw the declarations recognizing the court's jurisdiction, what would be the impact of such a withdrawal under international law and also geopolitically? Perhaps you could comment on that as well. Thank you.
I can take a shot at those, and maybe Irina will want to add. As a technical matter, it really doesn't make a difference whether Ukraine ratifies the Rome Statute. There are a lot of reasons to ratify. I think it's a good idea to ratify. But in terms of the actual jurisdiction of the court, the declaration functions just as ratification would. I think Irina's right that not ratifying may have a kind of a pragmatic import in terms of prioritizing Ukraine vis-a-vis other member states, but that's more of a policy decision. It's not a legal one. So in that regard, it doesn't make a difference. Now, in terms of the withdrawal question, that's a really good one, and we have not faced that situation. It is extraordinarily unclear under the Rome Statute what the right answer would be. My assumption would be that the Office of the Prosecutor would take the same position as it's taken with regard to Burundi or the Philippines or anywhere else, which is, you've given us jurisdiction, we've started an investigation, you may not have an obligation to cooperate with us a year from now, but we have jurisdiction to continue our investigation, and we will continue to. Obviously, the Rome Statute couldn't function and the ICC couldn't work if states could just kind of treat it like a yo-yo and say, we're giving you jurisdiction. Oh, you're doing what we don't want. We're taking it away. Oh, you're doing what we like. We're going to give it back to you again. It doesn't work like that. When a court says to the, when a state says to the court, go ahead and investigate crimes committed on our territory, that is essentially, for life. They can't just change their minds and say, sorry, our bad, we don't want you to be involved. So I'm pretty sure, even though there's some difficult legal issues, that the court would continue to have jurisdiction over the time frame that was contained in the original declarations. But I actually would be very interested to hear what Irina thinks about that. So
yeah, very good points, and I really like the second question. The first question on the ratification, I would like to add that there is a misconception and myth in Ukraine that ratification would somehow change the legal parameters of the ongoing preliminary examination or potential investigation. Those of you who read the second declaration submitted by the Ukrainian government in relation to Crimea and Donbass, it's mentioned there explicitly that Ukraine wishes the ICC prosecutor to focus on the responsibility of senior Russian nationals and also the responsibility of the terrorists from eastern Ukraine. However, the wording of the declaration is not binding. On the ICC prosecutor. By virtue of his or her mandate, the ICC prosecutor is supposed to investigate all sides to the conflict, something that we have already discussed and Kevin also mentioned. So by being a non-ratifying state, Ukraine gains absolutely nothing. Ukraine is just missing out on all the benefits being a state party to the Rome Statute. So, for example, Ukraine does not have a voice and cannot participate in taking any important decisions during the SAP meetings. Also, if Ukraine were a state party to the Rome Statute, then that would allow Ukraine to lobby for the situation of Ukraine to be handled within a reasonable period of time. And also, especially now, given the fact that the ICC does not have much resources, Ukraine would be in a stronger position asking the new ICC prosecutor to prioritize the situation of Ukraine. If Ukraine were a state party, Ukraine would be able to nominate Ukrainian nationals for senior positions at the ICC, for example, for the position of judge or any other important committees that are dealing with important matters. And also this would open a door for Ukrainian professionals, especially Ukrainian legal professionals, to seek employment in the ICC. Also, the employment is open to all the nationalities. However, the priority is given to those who have the nationality of states that have ratified the Rome Statute. And given that Ukraine is in desperate need of national capacity building and more professionals who know how to apply international criminal law, that would definitely be beneficial for Ukraine. So the conclusion is that Ukraine is gaining absolutely nothing from non-ratifying the Rome Statute, and this is just this is just fear mongering among Ukrainian politicians that if Ukraine were to ratify the Rome Statute, then the ICC prosecutor will initiate the cases involving the responsibility of the Ukrainian armed forces. The second question is a tricky one. It's an interesting one as well, because as Kevin said, there is no practice whatsoever. It has never happened that the state accepted the jurisdiction of the ICC and then later withdrew its declaration. It was actually the opposite that happened. For example, Ivory Coast and Palestine, they accepted that whole jurisdiction of the ICC, and then within a short period of time, they became state parties to the ICC. So Ukraine should be viewing the acceptance of that whole jurisdiction as the first step towards the ratification, not vice versa. And I do believe that it will be interesting to see if that were ever to happen, which and I hope it will not happen, what would be the position of the court? And it might be, as Kevin said, that the court will follow the Burundi scenario. So when Burundi decided to withdraw from the Rome Statute, this did not terminate the preliminary examination that was initiated by the Office of the Prosecutor. Burundi gave the jurisdiction to the ICC before, and Burundi was covered by the jurisdiction of the court before it decided to withdraw from the Rome Statute. And this is exactly the same position that could be taken by the Office of the Prosecutor. Ukraine conferred the jurisdiction on the ICC from 2014, and this declaration remains valid until maybe one day Ukraine will withdraw the declaration from the ICC. But hopefully it will not happen. I don't think it will be in the interest of Ukraine to withdraw its acceptance of that whole jurisdiction of the ICC. It will also show that Ukraine does not uphold its obligations under international law. So hopefully these are just some unsubstantiated rumors and myths that are being circulated in the media.
Thank you very much. And we've got a very interesting question from the member of the audience. So Anastasia thanks our amazing speakers for the webinar. And her question is about Ukraine's latest application to the European Court of Human Rights concerning Russia and its alleged administrative practice of targeted killings of its opponents. It's a very big news and very recent. So I was wondering whether you, Irina, or Kevin could comment on it. As far as I understand, Russia alleges this policy of Ukraine alleges Russia's policy of targeting killing of its opponents, not only in Ukraine but elsewhere. It also refers to Navalny, to the Salisbury killing. How do you think this might pan out? Would you be able to answer this question, or shall we leave it for the further webinars?
So I would like maybe Anastasia to specify which case she refers to. Is it the alleged administrative practice of persecution by Russia in the context of the Crimean situation, or it's the very last interstate application that was filed before the court? Because I'm not exactly sure which case she has referred to.
It's the latest one. It's not related directly to Crimea or Donbass. It's about the general practice of targeting political opponents. And they took this emblematic case of Navalny as kind of as a flag in order to file the case to the ECHR.
So I think it's a duplication of claims that Ukraine has already made in the context of other interstate proceedings. For example, when we look at the interstate application concerning Crimea, then the Ukrainian government alleged that the occupying authorities have been carrying out a persecutory policy in relation to the persons who are considered to be disloyal to the occupied authorities. So I'm not sure whether this extra case will advance or strengthen Ukraine's claims that have already been handled by the European Court of Human Rights. The Navalny case, it's different. Yeah, of course, it's sort of, now we not only have the Ukrainian nationals who are being targeted, who are disloyal to the regime, but no, we also have Russian nationals who are subjected to unfair trial proceedings in Russia. So the applications are much broader, of course, but in context of these situations, in context of the cases that have already been referred by Ukraine, I don't think that this very last case will somehow strengthen the already clear position of the Ukrainian government that Russia has been waging a persecutory policy against those who disagree with its regime.
Thank you, Irina. And we've got a question probably to Professor Heller. What types of crimes do you think will be addressed first in Ukraine's case? And do you think the expertise of the newly elected prosecutor might impact the prioritization of the crimes in the Russia-Ukraine situation?
I think I would leave the very specific question to Irina about which crimes might be the ones prioritized. I can certainly address kind of the larger issue about Karim's kind of courtroom ability. It doesn't really matter, in a sense, what crimes are actually charged if you don't have a very skillful prosecution team that has a reasonable chance of getting a conviction. And I think one of the reasons why I'm so excited about the results of the prosecutor election is I think you have a prosecutor coming in June who is unbelievably skilled in the courtroom and is capable of managing a team of equally skilled prosecutors. And I expect them to greatly improve upon kind of the track record of the OTP in obtaining convictions. There have been some very high profile acquittals at the ICC, rightful acquittals in my view, over the past few years. And a lot of that is due to lack of cooperation and lack of funding, et cetera. But it's also in large part due to problems within the Office of the Prosecutor and their difficulty in building coherent, effective, understandable cases. And I think no matter what ends up being prosecuted in the Ukraine situation, if that happens, I think you won't see a group of prosecutors under Karim Khan that will have those kinds of problems. I think they will be much more efficient and effective. But again, in terms of the specific crimes I think are likely to be teed up first, I imagine Irina is much closer to the facts on the ground than I am. So I think I would defer to her on that.
Yeah, so just like add a few words, I think that the prosecutor in her latest report on preliminary examination activities, she single out three major categories of crime which show a pattern of criminality on the territory of Ukraine. So she mentioned the detention-related crimes, unlawful imprisonment, torture, cruel and degrading treatment, the crimes that are being committed in the context of unlawful detention. Also, she mentioned crimes committed by the occupied authorities in Crimea. And the latest category of crime are crimes committed against civilians. So looking at this classification, one could say that the Office of the Prosecutor is prioritizing these three patterns of criminal behavior as those that will most probably lead to the individual cases. However, the specific crimes are always linked to the charges that are levied against the individual accused. And so far, we don't know how far down the chain of military command or political leadership the ICC prosecutor would wish to travel. So the major task for the prosecutor would be to identify the suspects, and then depending upon who will be the suspects. And my best bet on it that pro-Russian separatist rebels will be the first one on the list. Depending on that the prosecutor will have to evaluate the evidence and see how their conduct fulfills the legal elements of various underlying war crimes and crimes against humanity within the jurisdiction of the ICC. So it's very difficult to say what international crimes will be prioritized, as we don't know who will be the first suspects identified by the ICC prosecutor. Of course, provided, and this is an important disclaimer, it's not a given. We are still waiting for the decision from the pre-trial chamber to authorize the investigation into the situation of Ukraine.
And let me just add really, really briefly to that, you know, as a general legal matter, I think it is normally easier to prosecute crimes that take place in detention or that take place with civilians who are captured and you know, executed. Whenever you're talking about war crimes, crimes that take place in the fog of war, even deliberate attacks on civilians can be extraordinarily difficult to prove. Were they firing at civilians or were they firing at a military target nearby? Was it disproportionate? What was the military advantage versus the anticipated civilian damage? Those are extremely, extremely difficult crimes to prosecute. So insofar as they can get the evidence and the suspects, I would expect them to focus on the detention-related crimes like torture, extrajudicial executions, and the like.
Okay, going back again to the broader context, from Ukrainian local context, I would like to ask your opinion on the campaign to make ecocide an international crime and to kind of include this sort of crimes to the jurisdiction of the ICC. What do you think about those arguments? Are they good or not?
I mean, from my perspective, I care passionately about the natural environment, and I think the idea of criminalizing the intentional destruction of the environment, regardless of its anthropocentric effects, is a good one. Whether it's the kind of crime that should be added to the Rome Statute, and whether we should further complicate the work of the OTP there, I'm not so sure. It's worth noting that the war crime of causing disproportionate damage is not just about damage to humans, but is also damage to the natural environment. And this is a kind of a world first in international criminal law. Now, it's only in an international armed conflict. It doesn't apply to non-international ones, but that's a huge step forward, that you can't cause disproportionate damage to the natural environment, even if it doesn't affect humans, even if it doesn't, help them starve or destroy the necessities. The ecocide proposal is extremely well-intentioned, and as a broader level, I think we should firmly support the criminalization of it at the international level. Whether we should add it to the list of things the ICC should do, again, as I said, I think there I'm a little bit more skeptical.
Thank you. Irina, what do you think?
I passionately support Kevin on that. So I think if there is a will to protect the environment and to introduce additional crime that will protect the environment, this is something that could benefit potentially the ICC and will show that the international criminal justice has a broader reach as well. So I have nothing against it, but of course this should be followed by the lengthy period of negotiations among state parties to the ICC, and there should be political will to include this crime within the jurisdiction of the ICC.
Thank you very much. And I have a next question. There has been the discussion, and Irina actually mentioned that, about the lack of diversity at the ICC on different levels, and especially among the Defense Council. How would you comment on this lack of regional representation? I know that the ICC, it's public information that they have had certain outreach events in Georgia to incentivize the Georgian lawyers to register with the list of the Defense Council. How can we bridge this gap between, well, the typical brilliant, British QCs or, American, Australian, German, Dutch lawyers, and having more people from wider areas?
Do you want to take that one first, Irina?
Yeah, I can take it first. It's not a revelation to anyone, and I don't want to insult anyone, that the practice of international law and international criminal justice is dominated by white, older men from common law background. And there are reasons for it. The way the procedure works in international criminal courts and tribunals is adversarial. So those who have common law background, they are in advantageous position because they can argue convincingly cases in the courtroom. However, there was a great emphasis in the ICC that we have to maintain more diversity in international criminal justice. In particular, that we have seen the proliferation of situation across the globe. So for example, if a potential defendant comes from Philippines or Venezuela, it might be that the defendant would prefer to be represented by the defense counsel of his nationality, or at least the counsel that speaks his language. Also, when we look at the early example of prosecution in the ICTY, it was mentioned, for example, there was a great degree of miscommunication between the defendants and defense counsels, because first of all, they did not speak the same language, and they did not understand the cultural differences. So it would clearly strengthen international criminal justice if we have a greater diversity. But then if you want to be included in the list of practicing counsels in the ICC, you have to fulfill a number of strict criteria. If I remember correctly, you have to show that you have practiced not criminal law, but international criminal law for a number of years. And so, for example, if we want more legal professionals from Ukraine or from Eastern Europe to be included on that list, I don't think that we have that many professionals. Well, at least I don't know of so many professionals from Eastern Europe who have practiced before international criminal courts and tribunals. So on the one hand, we want to show that there is diversity. It's important to bring awareness about it, but it's also important that the criteria that you have to fulfill as a candidate to be included on the ICC list of practicing counsels are realistic. And so, for example, it's not only it's not only limited to people who have earlier practiced international criminal law, but it would also be possible to be included on the list of counsels if you, for example, just practiced national criminal law for a number of years.
So, as an older, but certainly not old, white man from a common law background, I wholeheartedly endorse what Irina said. And perhaps I'll just take a slightly wider perspective on it, which is, it isn't just about defense counsel, it is about every office and every organ at the ICC. There is not enough representation of women. There's not enough representation of individuals from the global south. There's not enough representation of non-common law and non-civil law backgrounds. And in and of itself, that lack of diversity should be a concern, but pragmatically, it should be a concern in terms of the treatment of women. I don't have to get into the just horrific history of the mistreatment of women and the sexual harassment of women at the ICC. The independent expert report, which everybody can read, is incredibly damaging on that regard, and justifiably so, and it needs to change. And it's not that appointing a bunch more women is somehow a magic solution to that, but it's certainly not an accident that a very older male dominated court would have an issue with sexual harassment, and we need more diversity in that regard. But even beyond that, I think there's another really important substantive point, which is, this is not a court that is just prosecuting crimes committed by white people in Europe. It is ostensibly a global court dealing with situations all over the world involving different races, different religions, very different social and cultural backgrounds. And how could a court possibly be sensitive to all of those differences if it's only staffed by, as Rita said, older white men from common law backgrounds? We have to have a diversity of people at the court, because the court has a diversity of work in the real world. And I think a lot of the problems that the court has had, from prosecution to outreach, stems from the fact that they don't have the kind of local knowledge and racial, ethnical, gender diversity that is required by the kind of work that it does.
Thank you very much, Irina and Kevin. And probably the one of the final questions would be about the current worrying domestic steps in the so-called, states which usually promote the rule of law. So Britain does have this pending the UK Overseas Operations Service Personnel and Veterans Bill, which basically proposes to introduce the limitation as to when the alleged war crimes committed by the British personnel abroad can be prosecuted domestically. And ex-President Trump also issued certain pardons to the people who committed war crimes abroad in Iraq. How do we address this situation? Because on the one hand, Ukraine looks up at Britain and so many other countries who say that it should also conduct proper investigations domestically and not introduce amnesties for international crimes. And on the other hand, we see that these states oftentimes introduce quite controversial policies domestically. Do you think this trend will also stay?
should I take a quick shot at it and then give Irina the final word? It's hard not to be pessimistic about these things. In general, states don't like others prosecuting their own nationals for international crimes, and they don't particularly like prosecuting their own nationals themselves. I mean, if there's a change of regime, like in Cote d'Ivoire, sure. But in general, we shouldn't be shocked when the UK passes a bill like that. We shouldn't be shocked when the United States does everything it can to avoid an American national ever ending up in the dock at the ICC. I don't think there's an easy solution for that. And I think we also have to recognize that 2021 is not 1990. I don't think the ICC could possibly be created today. It was created at a rare moment of optimism after the collapse of communism, in which the Security Council was actually working for a change, and the international community actually did have a commitment to international criminal justice. It doesn't have the same commitment to the international rules-based order that it used to. And I don't think that we should expect that to change. And I think we have to change our strategies to take into account the fact that, there will be no more Yugoslav tribunals or Rwanda tribunals. There probably won't be another Cambodia tribunal. There simply isn't the will. We didn't talk about universal jurisdiction, but that would be kind of my plea, that the future of international criminal law is at the domestic level under universal jurisdiction, and not even at a place like the ICC. The ICC is important, but it's always going to be limited by all of the things we've talked about tonight. So again, we should believe in international criminal justice, but we shouldn't freight it with so many expectations that we're only going to be disappointed in the end.
Thank you, Kevin. Irina, what's your take on that?
Yeah, so just a few words. Of course, every single state takes pride in their military. And so it's not a unique situation which is being faced by Ukraine, that we do not want to prosecute our members of armed forces who are considered as national heroes for the alleged violations of international humanitarian law. And then, Katerina, you rightly said, you gave us some examples from the UK and from the US, that we see that those almighty or powerful states, they try to do everything possible to make sure that their military forces do not face justice in national and international courts. So why exactly should Ukraine subject its members of armed forces to the prosecution, while other more powerful states do not do that? And I think there was a very troubling comment that was made by the President Trump. He said, we train our boys to kill and we prosecute them for that afterwards. And I think it was quite controversial when in 2019, I believe Trump pardoned three members of US military who were charged with war crimes, and I believe one of them was convicted of war crimes. However, we should not really see that these decisions taken by the national governments are popular in the eyes of the general public. For example, the decision of the Trump administration to issue paroles was quite criticized by the wider general public. And for example, the prominent members of the military stood against these decisions, saying that the members of the armed forces should follow international humanitarian law, and if they decide to protect the territorial integrity and to serve the interests of the state, they have to hold themselves to the highest standard. And for example, looking at Australia, and I'm sure Kevin can say more about it, we have seen that Australians also realized that they were complicit in the commission of some of the war crimes abroad. And so now I believe that there are some investigative steps that have been undertaken to unravel what has happened. But it's important to deliver the message to those who are fighting on behalf of the state that they should follow the rules of international humanitarian law. It's completely unacceptable that the members of military are implicated or complicit in the commission of war crimes, in particular against the civilians. And I think just to conclude, I would like to mention the quote by Martin Luther King, which was very much popularized by by President Obama, who said that the arc of moral universe is long, but it bends towards justice. So we shouldn't find any excuses whatsoever not to prosecute those responsible for international crimes. And we have to focus on bringing justice and reconciliation to the affected communities.
Okay, thank you, Irina. That sounds very inspiring. And thank you so much for these closing remarks. And thank you so much for this very, very interesting, fantastic conversation. I think it was the most interesting conversation related to ICC I've ever heard in Ukraine. So thank you so much for that. And we're privileged to be with you and to moderate this discussion. And also, I would like to thank to everyone who sacrificed your time, your maybe working time to attend our webinar, and please join us for the further webinars as well. And I would like also to say that you will be able to read the transcript of our today's discussion, at least in Ukrainian, for sure, on the website of the Media Initiative for Human Rights and also Ukrainian Helsinki Human Rights Union. Thank you so much again, and hopefully we'll see you next time.
Thank you, Irina and Kevin. Thank you to the
Thank you
audience.
very much.
Bye-bye. Thank
Thank you.
you.
Bye.
Bye.
Макс, я так думаю, ти можеш завершати вже трансляцію.